All right, this week we're going to look at creditors' rights. It's part of Chapter 15. Next week we'll take a look at bankruptcy in more detail. Secured transactions fall under Article 9 of the UCC. This is transactions that have to do with personal property, where you put up this personal property as collateral for a debt, and it would include things like accounts, chattel paper, which are writings evidencing a debt, commercial assignments, fixtures, instruments, other intangible property. So things of value of personal property that you could give as collateral, pledge them for a debt. There are different ways to create a security interest. You could have a security interest when the collateral is in the possession of the creditor, or there's a written agreement describing the collateral signed by the debtor. The creditor must give something of value to the debtor, and the debtor must have rights in that collateral. In other words, you can't give somebody something as collateral that you don't have an ownership interest in. Once those requirements are met, either it's in possession of the creditor or there's a written agreement, it's signed by the debtor, you give value and you have rights. The creditor's rights attach to the collateral. So attachment is kind of the first concept in secured transaction. The next one is called perfection. Perfecting a security interest is the legal process by which the secured party protects herself from debtor's default or a third-party claim against the same collateral. In other words, it's saying, look, if you loan this person money and they want to pledge collateral to you, I already have a prior security interest in that same collateral. A financing statement is one way to get the security interest. It's filed generally with the Secretary of State in the state where the collateral is located. An improper filing in the wrong place, wrong state, could render the security interest unperfected. It's valid for 5 years from filing, and it needs to contain the signature of the debtor, the address of the debtor and the creditor, and a description of the collateral by type or item. The description of the collateral needs to be specifically identified in the security agreement and the financing statement. You also could perfect without a financing statement is the collateral is transferred into the possession of the secured party. A security interest is also perfected without a financing statement when it arises under a PMSI, or purchase money security interest. And we'll talk more about when you get those in consumer goods. Basically, the idea is that you sell somebody consumer good and you use that good as collateral to secure the loan because they're buying that consumer good on credit. General rules of priority. In other words, if there's more than one creditor claiming a right to the same collateral, a perfected security interest takes priority over unsecured creditors and interest. And if you have a couple of unperfected security interests, then generally the first to file has priority. In other words, first to attach takes priority, first to perfect takes priority. There are some exceptions. They're listed here. Buyers in the ordinary course of business, buyer who in good faith and without knowledge of the defects, and they take the good free of a security interest. If the debtor does default, then there's some remedies. There could be a repossession of the collateral. This is kind of a self-help remedy, or judicial remedies. The court goes gets involved. The creditor sues to get a judgment and then execute or levy on a particular piece of property that was subject to the security interest. Liens, you may have heard of these before. They're encumbrances or claims against property used to satisfy a debt or protect a claim. The lien names are a little deceiving. A mechanic's lien is not for an automobile. Instead, it's to secure a lien for labor, materials, or service on real estate. A artisan's lien is really what a mechanic would get on a car. It's labor and materials on personal property. And then a judicial lien would come from a court decision, and that could be a writ of attachment, which would allow the law enforcement to seize the non-exempt property, or writ of execution where the court orders the seizure and sale of the debtor's non-exempt real and personal property to satisfy a debt. Probably have heard of garnishment of wages. It permits a creditor to collect a debt by seizing property of the debtor held by a third party, usually known as the garnishee. For example, an employer who owes somebody payroll. There are a lot of laws limiting the amount and type of wages which are the subject of the garnishment, both at the state and federal level, basically exempting certain income and limiting the amount can be taken out of the debtor's take-home pay. There's also a creditor's composition agreement, where a creditor agrees to take less than what's owed on a liquidated debt, and it's binding on those who agree because the consideration given by each is depending on one another. It's kind of like accord and satisfaction, except in the creditor-debtor relationship. A suretyship, in other words, this is when you agree to answer for the debt of someone else. A promise by a third person to be primarily liable for the debtor's obligation to the creditor. In other words, if a debtor can't pay, then the third person who agrees to be a surety would be primarily liable, and that creditor could go directly to them. A suretyship is an express contract between the surety and the creditor. A creditor can demand payment from the surety at any time after the debt is due, even before or instead of the original debtor. And as I was saying, the creditor need not exhaust all legal remedies against the debtor before holding the surety responsible. Guarantor is a little different. They have secondary liability, and basically the creditor would need to pursue the principal debtor first and then go after the guarantor. Statute of frauds requires a guarantee to be in writing unless the main purpose rule applies, which is basically if there was an oral guarantee to answer for someone else's debt that was intended to benefit that third person, it wouldn't need to be in writing. That's pretty rare. Actions that release the surety and guarantor would be the same as those that would discharge the guarantor. Surety can use any of the principal debtor's defenses except incapacity, bankruptcy, or statute of limitations. Those are personal to the debtor. And a surety could use their own defenses, except fraud between the debtor and the surety that is unknown by the creditor. Rights of the surety and a guarantor: there's a right of subrogation, reimbursement, and contribution. You might have co-sureties and some right to seek equal amounts from all the co-sureties. There are some protection for debtors. There's certain real property that's exempted, sometimes called homestead exemption for real property. This is usually state laws that permit entirely up to a certain dollar amount of exemption for a homestead. And there's also an exemption of personal property. You would need to look at the statutes for the specific exceptions. They do tend to change over time as values increase. Household furniture up to a certain limit, clothing, personal possessions, vehicles, animals within certain classifications, and equipment that's used in the debtor's trade or business up to a certain dollar amount.